Under the aforesaid facts and circumstances and discussions made above, this court is of the opinion that no case for interference has been made able to be made out by the petitioner for exercise of discretionary jurisdiction. In view of the same, all the three petitions stand dismissed. Consequently, the interim restrictions regarding holding back the payments for the supplies made by respondent numbers 5 and 6 stand vacated.
So,
May please the lordship. We are here for listing of this matter, my lord, selection and appointment. The next matter.
Election appointment of
My lord, it is post for physical visibility candidates.
post of what?
My lord, it's the assistant engineer.
Assistant engineer. Here in this bench. This bench too.
Bench 2. Bench
Bench 4.
no bench 2.
This bench too.
Bench 2.
Only yesterday something, especially we had taken bench 4.
Bench 2.
My matter is pertaining to bench 4 not.
Bench 4 not today.
yeah, happy your lordship, my lord. I beg to mention item number 5 of to the list. I have
Yes.
taken item number 5 of to the list, my
Yes,
lord.
sir.
I have taken the consent of all other respondents, my lord.
Hmm.
Can it be on 15th, my lord?
I appear for respondents number 9 and 10 in this case.
Hmm.
But in my contention, this matter is infructuous. Anyways, let him take instruction.
Instruction, my lord.
Let it.
When?
On 15th, my lord. 15th of this month. Thursday.
So today is
Today is 6.
what instructions are you referred to? Okay.
Well, so far, yes.
Letter number 5. 3. Your name? Where? Yes. Bhattacharjee. Sri Bhattacharjee, Learned Counsel for the petitioner. Praised for some time to obtain instructions. Also, on the other hand, Sri D. Chakraborty, Learned Counsel for the respondent numbers 9 and 10, submit that by flux of time, the writ petition has become infructuous. Be that as it may. List. The matter is adjourned to be listed on 15th.
Yes, my lord.
Thursday. Okay, 15th.
Obliged.
Wait, your lordship, it's concern on the other side of item 6 of today's list.
Yes.
It is wrongly listed. So I contain because pleadings are yet to be exchanged in this matter. It has to come in the admission column.
It's not required. Pleadings, is it pleadings required? There may be some court order for listing.
In fact, Malad, we have not filed. We have filed an affidavit, Malad, but it is not a detailed affidavit, Malad.
Not affidavit on merit.
Malad, in fact, we have to file an affidavit, Malad.
You're for which department?
I'm from secondary division.
Though this matter is listed for hearing, it appears that affidavits are yet to be exchanged. Full stop. Was there any order from this court for this thing? No?
Seen the previous orders. In this case, item
No
number
such-
6, no such order.
Item number 6, no such item, Malad. We have taken good time, Malad.
So last order
We have jointly checked the file.
for no hearing will have. Hearing. Full stop. Sri Khatonier, NJ Khatonier, the Learned Training Council, Secondary Education Department, accordingly praised for and is granted
4 weeks.
4 weeks time to file the affidavit in opposition. Full stop. List after 4 weeks for admission hearing. For admission. Yes, admit for us. Rule yes. Was rule issued?
No such order, Malad.
As far as I remember,
Oh, yes. Don't say it. List of after 4 weeks, along with the connected matter. Negative together. Connected root to the matter. Coming to 6 সাথে অর্ডার পাস করেছে না, বাট সময় একটু ঠিক হয়েছে, অর্ডার তো একটু ঠিক
Problem.
4 weeks.
Problem.
Yes,
Should I pray for listing of a repetition? Matter pertains to payment of increment, Lordship.
increment,
Petitioner is assistant professor. He hasn't got the increment.
motion matter,
Yes, Lordship.
new matter,
Not new matter, Lordship, old matter. Matter is of 2021.
2021.
Lordship, this week, any day if possible.
This week is not possible. This week you already fixed all the matters. We can have it on
Put them at
on
your
the
discretion.
16th of June.
16th of June. Oblige, Lordship.
We'll put up.
Please.
Yes, please.
If I had raised the facts with regard to the fact that the university has been functioning. And I was referring to the investigation under the PMLA, Lordship, volume 619. And
619.
619, and I was at page 625. That is 5.7.
Six one nine.
And was the relevant page, Lordship, 625. Check as well.
Yes.
This is, Lordship, basically on what would be the reason to believe. And
Paragraph,
I was referring to paragraph 5.7.
Apple child. Okay.
Your
As,
Lordship,
as per the table,
yes, 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 yes. 5.7 I had read, Lordship. May I take your Lordship from 5.8?
Hmm.
Thus, based on the order in TR so that the Chief Judicial Magistrate Shillong, dated 3/5/17, the accused persons not only withdrew 15 crores 10 lakhs deposited in the FDs along with the accrued interest on 5/5/17, but also withdrew an amount of rupees 12,79,66,454 from the accounts attached by the Enforcement Directorate of rupees 27 crores a month. Now, 27 crores was attached by us. They misled the court. They withdrew 15 crores 10 lakhs. On top of that, they also withdrew 12 crores. And thus, Lordship, the amount which was left with us is far less. It is now 1487,11,077. at the bottom of the paragraph.
One second. Now you say that this withdrawal has been done on the strength of taking advantage of an order dated 3/5/2017, right?
Yes.
But if 3/5/17 pertains to 15 crores odd, how can an attachment which was made by you came within the ambit of that order?
That is why, Lordship, if I may read further below. The accused misdirected the court of the Chief Judicial Magistrate Shillong by not letting the court know that the Enforcement Directorate had asked attachment orders.
Where are you reading?
5.8, Lordship.
Yes.
Uh,
5.8 which line?
It will be one, two,
After withdrawing, the accused have laundered the same, transferring his document.
I'm just. Lordship, middle, it will be 10 lines from below. By 30/12/2017.
Yes, yes,
I'm reading from
yes,
there.
yes.
By 30/12/2017, entire money transferred to this account have gone out.
Hmm.
Hence, the accused misdirected the court of the Chief Judicial Magistrate Shillong by not letting the court know that the Enforcement Directorate had passed attachment orders on the said accounts, which were allowed to be defreezed. There was also reason to believe that the accused had manipulated the bank officials for the release of the amounts, as the bank officials were very well in the know of the attachment orders and were directed by the Enforcement Directorate not to release the accounts. Thus, the balance amount lying in the accounts which were under attachment by the Enforcement Directorate stood at 14 crores 87 lakhs 11,077. Since the state of Meghalaya also realized that the accused persons had violated the Supreme Court's directions, that the amounts were to be deposited back in the same accounts from which they were withdrawn, a contempt petition was filed by them with the Honorable Supreme Court. The Honorable Supreme Court filed order dated 19/8/19 dispose of the contempt petition filed by the state of Meghalaya by accepting that the accused persons have deposited 15 crores 10 lakhs in the form of fixed deposit in the Punjab National Bank in its branch office at Greater Kailash. Therein, the Supreme Court had ordered that the accounts in which the CMJ group had deposited 15 crores 10 lakhs as per order had to remain frozen. Now, Lordship will see, here is the game which they play. However, Lordship will see the next sentence. However, ironically, the amount of 15 crores 10 lakhs had already been withdrawn by the accused on 5/5/17. They even misled the Honorable Supreme Court. They had deposited, but they never said that we had withdrawn the money. On 19/8/2019, they had already withdrawn the money before the Supreme Court order had come. Therefore, the Supreme Court order that it had to remain frozen was of no effect. The money had already gone. Lordship, next are those mutual funds and the.
No, see, the withdrawal was in the year 2017.
Yes,
5/5/17.
yes,
And after the Supreme Court's order, new FD was created in PNB.
no. Lordship.
Now, how was the
I'm just coming to that.
because the contempt they were let out in
I'm
the contempt.
coming to it. Lordship, if your lordship will again come to paragraph number 5.7
Yes.
in the earlier page. As per the table provided prepared by the bank account statements received from the Punjab National Bank, Greater Kailash, it is observed that CMJ University deposited a total of 15
Crores,
crore so and so in the bank branch in between 9/3/17 and 24/3/17. They deposited. Where they deposited? They deposited in PNB, whereas it was required to be deposited in Axis Bank. Because the amount was lying in the Axis Bank which they had withdrawn. Supreme Court's order was that they had to deposit it back in the same account, but they deposited in the PNB. Supreme Court says, okay, PNB
Now,
also.
how is your interest adversely affected by this? Whether it's Axis Bank or PNB,
The amount which was attached by the equity was from the Axis Bank. It was from the Axis Bank from where they had withdrawn the money. Now they deposited in,
the FDs. FDs are created in the PNB.
yes, new FDs are created in the PNB. Now they deposited in the PNB. Axis Bank, there is no money, only 14 crores something. This money, what happens? Supreme Court says, all right, since we have deposited, let it be frozen. But Lordship will see the next line in this one, 5.7. However, as seen from the above table, all the accounts amounting to 5.10 crores were closed on 5/5/17 itself. Further, it has been observed that CMJ Foundation took loans of so and so 10.92 crores to part finance those FDs. These loan accounts were all closed on 5/5/2017.
Are you contending that the FDs were created in the PNB much prior to the Supreme Court's intervention, which was also parted with, and only to show that the money was replenished, this was shown
Yes.
to the Supreme Court.
Yes.
That yes, we have withdrawn,
We are-
but we have already also created FDs in the
Yes, but
PNB, so they are secured. But this creation was done long before the Supreme Court order,
Supreme Court
and it was also taken away.
was,
And a loan was also there.
yes, they take a loan, they make these FDs, loan of course 10 point something. The day that they close the FDs, they also close the loans. Lordship will see that. 5/5. Therefore, our attachment
So,
remains.
one second.
Yes.
So, good for it. The fact that the FDs were closed was not disclosed to the Supreme Court. That
Now,
is order of the Supreme Court to keep the amount frozen was of no use. Because there was no amount, no of these at that time.
That was not brought to the notice of the Honorable Supreme Court at that point of time. Now that after which we have
This is a
collected the
serious
details,
issue of conduct in our court. See?
No, no, my
We'll
lord.
come back to, we'll come back to.
I'll,
Please notice.
entire narrative is wrong, my lord.
No, we'll come back to, please
Yes.
notice,
If the narrative would have been like this, it is the same investigating officer who had initiated the contempt there in the Supreme Court. He was well aware, and that is why the Supreme Court said deposit only the 52 lakhs, which is a shortfall. Before that, there was so much of things have happened.
we'll come back to.
Yes.
Yes.
now Lordship, if I may take your Lordship to page 626,
Next page.
626, 627.
Yes.
These are all the accounts. Lordship will notice they are in personal names.
Table 6.
Table 6,
Oh, the foundation is there.
foundation Lordship is there. 1, 2, very few. Lordship.
2 and 3.
Lordship,
2, 3, 4, 7, 8.
very few Lordship.
Not very few.
Lordship will see. I just,
Okay. The CMG. Oh, you may be right. Most of them are in personal name.
most of them are in personal names.
These are what? Table?
These are Lordship, this amount of money which has been invested by the individuals. Lordship will see, of course, the foundation, some amount is there. And Lordship will come to the next table.
No, this balance means what? This is the amount lying in the individual account. Most probably it appears the last column is the amount lying.
in the- This is under account. And Lordship will see the next table where the money has been invested.
Here in page 26, the table, how many accounts are there?
This first,
34. No, not
no,
34.
it's 46.
46 accounts.
46. And the next table Lordship will
Most
see,
of them not in the name of foundation.
yes. Lordship will see table 7. All in personal names.
And 620. Table 7 is 628.
Lordship,
Table 7 is 628.
628 and 629. Ends at
Well, what is this? Accounts in mutual funds.
in mutual funds and LIC that has been invested,
Investment.
investments. And Lordship, table 8,
These are
Table
accounts how many?
Lordship will see the properties that have been purchased
This is 11 accounts.
during the
Hmm.
relevant period.
Here,
And
one
all-
second. Table 7. Table 7, all the investment are individual names.
Are individual investments. And table 8, the immovable property purchased,
This amounts are what, 9 crore, 9 lakh, no, 9 crore or 99 lakh.
which Lordship,
What's the amount?
total is
100.
4 crore 62,
No, the individual amount. This is 9999,
Lordship is
900.
9 lakhs 99,900.
9 lakh, all in that manner almost. Then table
That is
8,
Table 8, Lordship,
table 8 at page 629.
629 and close to 633.
This is what? Land.
These are lands purchased in Bihar at a relevant point of time. Now,
What number?
it is seven purchases
Of land at Bihar.
in Bihar. Now, under these circumstances, Lordship, the question would arise whether there is a reason to believe that the accounts should be attached or not. Now, Lordship has noted how courts have been circumvented. They are making claims that the university is running, which legally it is not. Just to get hold of those accounts, and Lordship has noted how much is there in the account. 83 crores and all is the proceed of the crime. 81 crores and all they have already withdrawn. They have already withdrawn.
From where do you come to the first figure, 83 crore?
Lordship, that is reflected in the charge sheet.
Okay, will come. And 81 you have said already withdrawn.
Yes, that is also reflected. Therefore, Lordship, my contention is, Lordship, there is every reason to believe that if the accounts are decreased, if the accounts are left open, this money will also go out. As it is, I would submit that the university is not functioning. Therefore, the necessity which they are espousing, that we require the money to run the university, has no legs to stand on. Now,
You may want to say that the day-to-day expense which has been argued, there is no question of day-to-day.
it does not arise at all if they are on the university itself. If they have got something else to do, that's certain. Because at the moment, Lordship, I have shown you, Lordship, that by operation of law, the university cannot function.
Stay order, 2 week window.
That 2 weeks, they have closed it themselves. They have gone to the Supreme Court now. There's a date every time. The query that has fallen from the Lordship is now that there is a stay of the proceedings in the trial court. The proceedings of the PMLA continue on. Now, also, so far as the investigation done by the police and the charge sheet filed by the police for the court of the climate magistrate is concerned, in my humble submission, that is a different domain altogether. That's an investigation done by the police. We have found so and so. That is the amount. But so far as the investigation done under the PMLA Act is concerned, it is not done by the police. Because the police will go only to the extent this money is found with him, this money is found with him. So far as PMLA is concerned, the authorities will investigate then after receiving the money, where further it has gone. Therefore, if there is a stay of the proceedings before the court of the learned magistrate, that ipso facto will not call for a stay in the PMLA proceedings, because the investigations in the PMLA is on an independent footing altogether. And in that connection, Lordship, in that connection, Lordship, even the Supreme Court, while rendering its judgment in Vijay Madan Lal Chaudhary, in paragraph 107, notes that a special court may continue to try such scheduled offence for the trial of the scheduled offence and the trial in connection with the money laundering are in any way required to proceed independently. This is because the offence of money laundering by itself is an independent offence in respect of the process and activity connected with the proceeds of the crime, which may have been derived or obtained directly or indirectly also. Because there might be a person who is sitting behind, who is not coming to the front. There might be a person who is sitting behind, who may also be involved. May have been derived or obtained directly or indirectly by any person as a result of criminal activity relating to the scheduled offence. Lordship, our same view has been expressed before in a case before the Jharkhand High Court. Lordship, I will raise the bill. This Lordship that the Supreme Court has stated would be on the basis of the explanation given in section 44 of the
PMLA.
because in any case, Lordship, what will happen? Section 44.
Yes, explanation.
44. I'll take your Lordship to the explanation, because here Lordship will note while the court below is looking into the charge sheet filed by the CIB, any offence under the PML has to go before the special. This particular court will not look into it. Therefore, both the proceedings will be independent of each other. Explanation: the jurisdiction of the special court while dealing with the offence under this act during investigation, inquiry or trial under this act shall not be dependent upon any orders passed in respect of the scheduled offence, and the trial of both sets of offences by the same court shall not be constituted as a joint trial. If the same court is looking after that. Now, Lordship had indicated basically, Lordship, on the facts and
Yes.
Lordship had indicated that they are, Lordship, in fact, ready to give those land documents, securities. And now, Lordship, I have gone through the act, search out. I do not find any provision in the law which would give liberty to the accused persons or give liberty to us to take any other property as security. I have not come across any decision of any court on the provisions of the Act itself, Lordship, that would suggest that such a measure can be taken. Because, dear Lordship,
Is there any precedent? No.
I have not. And so that is why, Lordship, I would submit, Lordship. Land is something, but the accounts that they have maintained, land of
No,
course,
more than that, it may not be, the proceedings are not like a civil court where you secure the asset.
Lordship.
Here may be the culpability is involved. So question of security probably, I would not know whether there are precedents or not. With Mr. Singh.
Lordship, at least I have tried my best to find out if it is okay. In fact, I do not find anything like that. Lordship. Therefore, the
So that point we'll explore whether culpability can be.
because
safe.
here there may be more attachments than one. There is no limit to the number of attachments that can be under the MLA so far as the investigation is concerned. Here also, they are challenging the first attachment, the second attachment. Now, if the investigation goes on, and further something is found out, then what would be the consequences? Lordship has to be the.
What is the stage of the investigation?
Now, Lordship, so far as this is concerned, Lordship, now we have referred it to the adjudicating authority.
So where is the scope of further things coming up? Now, Lordship, so far as attachment is concerned, Lordship, proceeds of crime is 83 and all. What? We, as on date, attachment with us is 14 crores something. Because the rest we say have been taken out by them. So, You have secured for only 14 crores.
yes. So far, it's okay. So, now till the entire receipt is attached, you can go attached. So that would be my answer. Because ultimately, Lordship, we will have to see whether the parties before your Lordship are here with clean hands, because Lordship will bear in mind, the Act provides an alternative remedy. Act provides an alternative remedy, and this court has passed a judgment on that. In Lordship, WPC 81 of 2019. If I may,
Yes, please.
where the court
On-
has
on-
said that when there is an alternative remedy available,
It was passed in context of the PMLA.
Lordship, especially paragraph 10,
27(9).
WPC 81 of 19. Huh?
Paragraph
10.
Ten. Yes.
Then I take your lordship to paragraph 25. 24 and 25. From the aforesaid, it is clear that the present petitioner shall have opportunities as provided under the Act and educate the same before the authority under the PMLA Act as discussed herein. Accordingly, in view of the foregoing reasons and discussions, this court is of the considered opinion that the present is not a fit case where this court would interfere with the order of provisional attachment in exercise of power under 326 of the Constitution of India. Inasmuch as this court has held that the authority is having power and jurisdiction to issue the impugned order of attachment, and that the adjudicating authority has the power and duty to examine the validity of the order of attachment and test the same, including the ground of satisfaction that is required under section 5(1)(a) and (b) of the PMLA Act. Accordingly, the provisional attachment order is not intercepted. Petitioner shall have liberty to avail its rights to file reply before the adjudicating authority is to advise. Now, in this particular case also, the case before your lordship, the matter is before the adjudicating authority. Now, how the adjudicating authority will decide? Adjudicating authority will issue them a notice to show cause. They will be heard. It is not a case that the adjudicating authority will always be in favor of the PMLA authorities. If there is anything that the petitioners can show before the adjudicating authority, then the proceedings will be brought there and there. And in a case where it goes against the PMLA authorities, ED authorities, ED authorities can also file an appeal under section 26. If the other party is aggrieved, they can also go for an appeal under section 26. So therefore, since the matter is already before the adjudicating authority under section 8, it should be best left to the adjudicating authority.
No, this submission of your, in the context of the prayer meet, they are not asking for passing of the proceeding.
What they are asking is to stay the proceedings.
No, not even that.
In a way,
The
because the-
relief has been molded. Prayers have been molded. That let the proceeding go, but let the amount which is outside the ambit of the predicate offence, the entire amount, let it be, let there be an order that this amount can be utilized, and for that necessary security would be given. We are only on that. Otherwise, on merits, we are not too much inclined towards the petition. But the relief has been molded.
That I would humbly submit to the Lordship, seeing the conduct of the
That you have argued.
that Lordship will see.
Hmm.
And the
Because
most-
this argument of yours cannot be necessary in view of the
yes,
submission made by the senior counsel. We are not touching the adjudicating process.
I'm okay. Now, whether the conduct of the petitioners would entitle them to the relief they are asking. My humble submissions. Because Lordship has seen at each and every stage, they have tried to circumvent the process. Had it been a clean case coming forward, even Lordship will remember the first day that I made my submissions. Lordship will remember when the governor
Hmm.
asked some queries, some explanations. How they answered? They answered to the council. The chancellor is self-appointed. Mr. Jha is self-appointed. There is no approval of the visitor. Endowment fund, today they create, tomorrow they withdraw. The university is running without any endowment fund. No university can do that. I'm just giving the instances. Orders passed by the honorable courts, you deposit money in a certain account. I deposit it in another bank. It's the magnanimity of the honorable Supreme Court or the judiciary in this country, I would say. That yes, they have deposited it in some other place. All right, let us accept it. That is the magnanimity of the judiciary. But the judiciary has been taken for granted. Lordship has seen from the charge sheet 83 crores and odd collected, 81 crores and odd withdrawn. Where is the money invested? Land, mutual funds, not in the name of university. Yeah, of course, university want to Lordship has seen. Most of them, 90% of them invested in personal interest. Under those circumstances, Lordship has to consider whether Lordship will allow them. It is, I would humbly submit, Lordship, it would set a very bad precedent. Because Lordship has noted, the lives of the students have been spoiled. So many, I have taken your Lordship to the orders passed by the Allahabad High Court. Running an university from a dingy room in Shillong. At that point of time, I am between Lordship 2010 and 2014. And Lordship has noted how many degrees, diplomas, doctorate degrees they have given, 20,500. He says 27.
Not me, my lord, they are saying. The
Well-
findings are different.
And now Lordship has also taken note. University starts in June 2010, and in the same year they award degrees. When were the classes conducted? It is basically a sham. It is basically a sham. They have looted the poor students. They have played with the life of poor students. And in my humble submission, Lordship will not allow them. They deserve severe punishment.
We are not deciding that.
That was
This will be preempting some of the priority.
that would be for the special. Now, under those circumstances, I would only submit. This is not the case.
My friend's narrative is all very good, my lord, in case only the allegations are taken without taking note of what the facts are. Kindly have
Lordship,
this first judgment.
Lordship, may I? Lordship, with your Lordship permission, can I?
Yes. Ask your colleague to be here.
Yes. Kindly have one judgment, my lord, which,
You are Amanpreet,
yes, ma'am.
Amanpreet Singh.
Amanpreet Singh, my lord. No, the other judgment. Kindly have this judgment, my lord, because this clarifies, my lord, how it all started, commenced.
Okay.
This is page 300, my lord, annexure 15. This is volume 2. in writ petition 2723. This is
300.
by the Honorable the Chief Justice, my lord, of Meghalaya.
What is the judgment dated?
This judgment is dated, my lord, 12th of August 2015.
12/8/15.
Yes, my lord.
Meghalaya.
Meghalaya. This is affirmed by the Supreme Court also. Supreme Court dismisses the SLP filed by the state of Meghalaya.
What is
But this one was with regard to, my lord,
who was the petitioner?
my petitioner is Govind Jha and Gopal Jha, who are one of the my petitioners here also, and accused in the PMLA. They had invoked the jurisdiction of the High Court for seeking, my lord, quashing of the non-bailable warrant.
482 petition.
Yes, my lord, it was a 482 petition. But I just wanted to take my lords to the observation. And my lord, because why I wanted to show the observations are because their reason to believe stands demolished by the observations of the Honorable by the High Court, affirmed by the Supreme Court. On all sets.
Yeah. Which page?
My page 304. Para 5, my lord. Because their whole, but they have raised twofold of arguments, my lord. One are all civil in nature, in the sense where the Supreme Court is scion of the matter right now. State is also challenged that very order. State has also the whole premises, my lord, I must explain, is Justice Moray's order, division bench order in appeal number 14. Justice Moray's order, my lord, says two things. One, he says is the single bench order in writ petition 174 is set aside. 177 is set aside. The trial, the High Court single bench is directed to rehear the matter on merit and decide afresh the entire dissolution of the university. And in the integram, they say while allowing the university to continue functioning and granted us 2 weeks of status quo. We immediately challenge it before the Supreme Court. Supreme Court immediately grants us the status quo.
No, the immediately was after 2 weeks.
I'll explain, my lord. Immediately in 2 weeks, my lord, we made a mention. The period was for 2 weeks. It would have expired on 21st.
You did not go before the single judge.
We never went before, but the matter is now pending before the single bench, again before the Honorable the Chief Justice, and he has also now stayed the entire matter. I recently appeared, because I am appearing in this matter. So the single bench has now stayed the entire matter to await the outcome of the Supreme Court.
Stayed which matter?
Stayed the proceedings under 177 while taking up the remand matter. Now single bench is now hearing the remand matter. Supreme Court has stayed the entire order of the division bench, status quo. State has also challenged the division bench order, saying that the division bench order is wrong. There should not have been any remand. So status quo in that matter also. In the SLP filed by me and in the SLP by the state also, both are there before the Supreme Court. So while the Supreme Court was hearing, it's a part third matter. Supreme Court said that while both of you are here, why don't we remand the matter back to the division bench?
Yes.
And let the matter be reheard and allow the university to continue, and university is actually continuing.
Where is that order of the Supreme Court?
But that order is that I'm saying there's a part third matter. Like my lords are hearing every day.
No,
And
is
some
there any-
observation comes from my lords.
No, the last submission of yours that the university is functioning pursuant to. certain
My lord,
directions.
any court commissioner can be appointed and the university can be seen. My lord, it is operational. It's very much operational. Rather, we have been recently granted a new recognition by another autonomous authority, giving us affiliation for starting a new course. I can produce those documents.
Which authority?
My lord, This is a Rehabilitation Council of India, my lord. A statutory body of Ministry of Social Justice and under Empowerment, Development and Employment for disability under the Disability Act, my lord. For giving education to disabled students also. So they have asked us whether we can take up the students from disability like blind students and every sort of or whatever is provided under Disability Act. So we have been granted that affiliation also for starting a new course or a vocational course for all these kind of disabled people.
When was it?
This is, my lord, very recently, 20th of May 2023, my lord. And rather they have come and inspected the premises also, whether our premises, my lord knows, under the Disability Act, everything has to be in order. Whether there is a ramps and whether there are lifts and whether there is a braille, everything has to be there. So we had set up the infrastructure. So they have recently made an inspection. And the report is awaited, because once the report gets cleared, only then we will get the final outcome. But this is only with regard to that we are functional. Now kindly have page 304. Because my learner friend's argument says there is no chancellor. And the chancellor issue is before the Supreme Court. Single bench says deemed approval of the chancellor. That has been upheld by now by the again Supreme Court status quo. So the status quo has to employ to the appointment of the chancellor also. Because now everything is under before the Supreme Court, my lord. This deemed approval, because our argument before the single bench was, and which was affirmed, that there is a deemed approval. Governor, whether he has given or not is not the question. It was pending from 2010 onward to 2013, the governor having failed to take any decision. We grant them the deemed approval and the court granted us the deemed approval. Which matter again was challenged, and then there have been various ups and downs. Thrice the matter has come from the Supreme Court, and it came before this honorable court also by way of transfer. And again back to the Supreme Court. Supreme Court again transferred it back to the Meghalaya High Court. Again, Justice More decided it partially against us and partially in favor of the government. Matter is again now status quo in the Supreme Court. That's all the ping pong, my lord. But kindly have 304, the observation of the single, because this order has been affirmed by the Supreme Court. The visitor, kindly have para 5.
Affirmed the final order is passed.
Because this SLP filed by the state against this order was dismissed.
Please read.
But I am only taking it as observation. I'm not saying this becomes a finding, because ultimately, my lord, I also see, practicing on the criminal side, that this ultimately matter was only under 482. And these observations are nothing but observation. So I'm not taking them as a finding. But this is only to show, my lord, how reason to believe of theirs has to be negated by some observation. Para 5, the visitor also did not raise any objection to the appointment of the chancellor, even after receipt of the aforesaid letter dated 1 April 2010. However, the state government issued a notification dated 17/6/2010, whereby sanction was accorded for establishment of the university in accordance with the guidelines issued by the UGC. Thus, the university came into being and was established in accordance with the law. As per the, kindly mark this date, my lord, the notification, Gazette notification 17/6/2010. So we started functioning from this very day. And my learner friend's argument is also I will meet, because we had an earlier institution, my lords must be knowing about there was a very old establishment college called Shillong Engineering College, run by same Mr. C.M. Jha, Chandra Mohan Jha. And it was affiliated with NEHU. And after de-affiliating from NEHU, we got it affiliated as per the CMJ Act. As per Section 7 and Section 8, we brought that institution within our purview. It was being run from 1990s. We bought it within our purview, and we had the affiliation from the engineering department to run a course under the CMJ University for engineering wing. So we merged all the people into ourselves, and that's how their classes, my lords knows, under the TC, if some affiliation gets or devalidated or re-affiliated, the students don't have to start afresh. You give them classes from wherever they are. That's how, my lord, some students, my lords, may see that they were given the provisional completion certificate in the year 2011, even though the university started functioning from 2010 as such. Thus, the university came into being and was established in accordance with law as per the provisions of section 21(1) of the CMJ. The Board of Governors was to consist, amongst others, one representative of the state government, one educationist of repute to be nominated by the state government. Now I pause here, man. Two people from the government are there. Every board decision with regard to shifting of the university from Moderna Laitumkra to Jorabad was taken in the minutes of meeting in the year 2010, and we purchased this 50 acres of land in by way of two land parcels, 26 and 25 acres, making it total around 52 acres of land, which we have given to this the original land deeds to this honorable court only. And every decision with regard to opening of the accounts also,
Yes.
so many accounts came to be opened, were taken in the minutes of meeting attended by these two government officials. Now, these two government officials are not made accused somehow or the other in the predicate offense also. Neither the challan, neither they are put in a column 2. They as if they never existed. So the investigating report, and that's what we made a challenge in the Supreme Court, in the High Court before Justice Jingdo, and where the trial court in entirety has been stayed. Firstly, we made allegations against the investigating officer. Now he's no more. He died few days back only. The learned SSP, and there were so many allegations against him for taking away my 80 lakh and converted them into 8 lakhs. Then we made a grouse that there was never 83 crores. There were never 83 crores. Rather, when we created all these accounts or separate accounts, we shifted the money from this account to that account, and whereby double entries had taken. In all, there were 47 crores at the best. And that is the reason my learner friend says they are magnanimous. Rather, the same words were used by the investigating officer that he is magnanimous enough. And that said in the affidavit, my learner friend said over the on the bar only. But the investigating officer wrote affirmed in his affidavit that they are magnanimous enough to only seize 43 crores because that is the only income they could find. Now, my learner friend made so many allegations, 83 crore, and 81 crore withdrawn. But if 81 crore were withdrawn, how can there be 43 crores also?
But your submission regarding the engineering degree, that degrees and diplomas were given on the same year. Or
Never
next
degree.
year.
Well, there has never been a, that's why I wanted to read this judgment. This judgment says these were all the certificates. That's why 20,000, 27,000 and odd.
Certificates only pertaining to engineering.
No. Certificate pertaining to every, there is a trimester system. So every student will generate, even if I take a lesser grade, 5 subjects and 5 certificates. So if you take 6,000 students in all who would come and go, at the best they will have the same amount of certificates as were found in the investigating report in the charge sheet. They were only the certificates. And as regards the PhD degrees also, the court record that they are only the provisional certificates. Convocation never took place.
But provisional certificate can you give within a year?
No, that's precisely my learner friend's affidavit or whatever his compilation are, that was given for after 2 years. Kindly have my learner friend's own document. He has given with regard to a person called Mustafa Raza Khan. He started his he enrolled with us rather in the year kindly have his 1080 2086 page. I don't know because my friend here changed the pagination numbers. So I don't know which one is correct now. 2086. He started. This next year 13. Next year 13 in his compilation.
101072.
One
One.
again 1079. I'll correct it. My
1079 of our compilation.
1072.
Sorry, 7677. This one
Kindly
has
have 1077.
this compilation.
No, 13. The document, yeah. 1079. Kindly have 1079. He takes admission in April 2011.
1079 is what?
Is the annexure 13 is a letter to the enforcement directorate by Mustafa Raza Khan. Probably ED department chose one person and asked him when did you got enrolled and everything. They wanted to have a parallel investigation. He enrolls in April 2011. We have already started functioning in the year 2010. Now kindly have his next document. This is 6/7/2011. This is the our letter. PhD coursework completion and synopsis approval.
Now, what is the objective of this letter at page 1079?
They were doing a parallel investigation. They wrote, the investigating officer must have written, kindly it is requested that I received your letter. This is from Enforcement Directorate. It is requested that I received your letter dated so and so, file number so and so. So I'm informing that I have done my PhD from CMJ University. I have taken admission in April 2011. That time I have deposited 24,000 cash more during admission time. Thereafter, university called me, if you submit the fee, then you can continue the course. Otherwise, you will be discontinued. Then I have submitted my balance full fee through check. I am sending the copy of all my documents and ITR balance sheet of college and self. I am ex-Indian Navy. I have shown my pension also, my ITR. Now kindly see, Malad, he says I am a ex-Navy guy. He must have been a master's degree, because otherwise you can't enroll yourself to PhD. Now I have got the list in my compilation. All these people who got enrolled under the PhD, they are working as directors of some government institute, working as associate professors, principals. They are not nobody people, not from ground level people who have never done their masters also. They are all somebody or the other, PCS, HCS, basically into executive body. They are all into something. There is never a case, there has never been a statement under 161 or 164 at the best that they say we purchased the degree, we went there and we purchased it over the counter. Now this guy enrolls himself in April 2011. Then there are various correspondences. Kindly see his certificate also. 2013. Page 1083. My God. All these are his documents only. And his Viva voice is held on 28th of February 2013. So almost 2 years. And every procedure has been done. Well, normally, if his allegations are to be taken to be, ED's allegations are taken to be at the face value, you go to the counter, purchase a PhD degree and come back. I have done so many matters and so many universities after Dr. Yashpal's judgment came to be closed for that accounting. That is not the case. The person is made to wait for almost 2 years. My friend kept on saying under the tin shed. I have studied under the tin shed. I studied in National Law School when it started in 1987. My lords knows that was started under the tin next to the Bangalore University. I still have got the photographs. And now there are seven 7 honorable judges from that law school. And my father did PhD in 6 months, and he went to the United Nations. If I have got the own example at my house, my brother did it in 8 months. Delhi University. Can the ED now says that you have done your 6 months, then you have to be arrested? Here the person Mustafa starts his April 2011, completes his in February 2013, almost 2 years. And then he is given a provisional certificate. When he was to be, the convocation was supposed to be held, everything got turmoil. Then we were under the, we have been beaten. And that is exactly the case. That's why I wanted to read this observation before I come up to all this. Kindly see now. All history is reiterated. It has been reiterated because my learner friend says we wrote to the governor through our lawyer, because the day they make a complaint at 11 p.m., which records from the DGP, I have got the FIR also. FIR record shows on this complaint, please go and investigate. Rather going to investigation at mid of the night, stroke of the night, they registered an FIR on the same day. Non-cognizable offense. And on what basis? That the governor has seen some advertisement of some persons of Assam being granted or about to be granted the PhD degree. 6 students. And that came in the newspaper, that is part of the challan. On that strength, reliable information, the governor, and that comes here, the honorable governor asked the chief secretary, that is Mr. Rao, who was ultimately the complainant, to go and register an FIR mid of the night. The FIR registered. Next day they start the manhunt. Next day I'm sealed. On 26th is the FIR. 27th, they ransack the entire university. They seal it also. 2 premises got sealed. My learner friend says in 2013, neither there was Jorabad nor there was Laitumkra. I went to the Malkhana myself and saw the record. And that is why we got that order from Justice Dingdo that the entire records be given to us. And that is why we produced those 3,200 pages before my lords, to show that the university was seized at the time when the UGC also made an inspection on 1st of August 2013. If we are lying seized, we are sealed. Now the question, I done so many criminal law matters. If the premises are sealed, how can the UGC be granted the permission to enter the premises also without permission of the court also? And that is precisely the matter now in the pending in the High Court, which is to await the outcome of the main SLP, which is pending in the Supreme Court with regard to Section 48 against the UGC expert committee. That if the university was sealed as per the court order and as per the investigating officer, how could you have done an inspection without seeking the permission of the court and without any intimation to me? And that's the reason UGC as of today also, yesterday, the UGC ranks me at 473 private universities operating out of 10 in state of Meghalaya. And the status of the university is it's functional. As per the UGC report, I will show that. But kindly have this now. The state government nominated 2 members, including the educationists of repute in the board of governors of the university by the letter dated 16/7/2010. On 26/4/2019, all of a sudden, the deputy secretary to the governor of Meghalaya sought lots of information, particularly with regard to the admission of students within 3 days by 29/4/2013 from the sponsor. However, without waiting for the reply sought by the deputy secretary to the governor by the letter of even date, namely 26 April 2013, the principal secretary to the governor directed the Director General of Police to conduct investigation into functioning of the university and launch criminal proceedings if investigation revealed commission of criminal offense against the university. Pursuant to the letter coming to the principal secretary to the governor, the state CID registered the case number 2 4 of 2013 under section 420, 406, 466 IPC on the same day, that is on 26/4/2013. Thus, according to the petitioner, without waiting for requisite information sought to be supplied by the university, YD letter dated 26/4/2013, a false and frivolous criminal case was registered against the university and its officials, which smacks of ulterior motive and malafide intention of the state authorities, as well as high-headedness of the first informant, namely principal secretary to the governor. The registration of the case in the aforesaid manner is illegal and unwarranted. As a result of registration of FIR, several officials, say as many as 9, including Chandramohan Jha, were arrested. However, Mr. Chandramohan Jha, allegedly to be the principal accused, was enlarged on bail. The officers so arrested and thereafter enlarged on bail are mentioned in the petition as follows. Now, I would not read. Kindly have now the observation. Para 14.
Page.
This is page, my lord, page 318. All the rival contentions were heard. This I'm reading it only for a purpose of observation and how their provisional attachment orders, both of them, lacks reason to believe on both counts, on the financial accounts as well as on the factual grounds. On due consideration of rival submission, it appears that the cause of action leading to filing of an FIR does not seem to be exactly a criminal one. Under the epicenter of controversy seems to be some kind of grudge in the mind of the then governor of Meghalaya over establishment and smooth functioning of the CMJ University, constituted under the CMJ University Act 2009. Such an impression can be gathered from the pleadings of the petition, showing unusual conduct on his part in dealing with the matters connected with the affairs of the university, and also from the judgment of Honorable Single Judge, Mr. Justice TNK Singh, who has decided and allowed the writ petition number 177 of 2014. The penultimate para 29, I would not read more. Have para 6, now para 16 at page 320. I'm reading bottom 8 line at page 320. My lord, the University Grants Commission, supposed to be the only authority to regulate and ensure implementation of the norms and standards of education in universities, has supported the stand of the CMJ University. The CMJ Foundation, being sponsor of the university, claims to have spent hundreds of crores in creating the university. The appointment of Shri CMJ as Chancellor was never questioned by the governor. Questioned by the governor being the visitor, nor did he ever rejected the proposal. All relevant information used to be regularly furnished by the university to the visitor, which also included the information about engagement of more than 300 well-qualified PhD guides.
Yes.
I'll read it again, Mark.
Yes.
All relevant information used to be regularly furnished by the university to the visitor, which also include the information about the engagement of more than 300 well-qualified PhD guides to supervise the research works of PhD students. This information was also furnished to the UGC under the regulation of the university. Under the CMJ University Act 2009, Board of Governors alone was empowered to control the affairs of the university, which amongst others also included 2 nominated representatives of the state government. Strangely enough, the nominated members of the Board of Governors were never questioned or interrogated by the investigating officer or made to suffer a criminal charge. The petitioners have claimed that the university was functioning smoothly for the past about 3 years without any interference from governor's office, till the governor visitor all of a sudden declared all admission illegal and issued direction to the CMJ University to recall and cancel the qualification degrees granted to the students of the university, and thereafter, without waiting for clarificatory reply from the university to the letter dated 26/4/2013, directed the registration of case through the principal secretary by way of submitting a complaint of the event. It is also mentioned in the additional document filed by Shri CM Jha in the instant criminal petition and the petition so and so, that the rapid rise of the university had become an eyesore of the present state government of Meghalaya, which has a personal long-standing animosity towards him, Chancellor of CMJ University, for his proximity and long association with some other prominent political leaders of Meghalaya. Since those leaders went out of power, therefore the university as well as the Chancellor has been victimized as a blatant display of political vendetta, notwithstanding the fact that among all the private universities in Meghalaya, the CMJ University is the only private university having its own permanent campus on 30 acres of land and more than 2 lakh square foot building of area, including modern classrooms, well-equipped laboratories, and good quality accommodation for residential students. The then Visitor Governor Shri R.S. Mushari, in a series of letters between 4th of April 2013 to 13/4/2013, issued such direction and recommendation, which not only led to closure of the university, but also its dissolution. Even the local subordinate judiciary, now kindly see the conduct of the judiciary also, instead of appreciating the case on merit, was swayed by the negative media reports and succumbed to the pressure of the state government. The matter went up to the Supreme Court, and the chancellor was granted temporary anticipatory bail by the order dated so and so, and thereafter by order dated so and so. Honorable Supreme Court directed the state government to give an opportunity to the university to rectify its shortcomings, if any, in the administration and management as required under Section 48 of the CMJ University Act. The order also directed the sympathetically considering the petitions of students whose degrees and admissions were declared illegal by the visitor governor. It is averred in the written submissions that in utter disregard and defiance of the order of the Honorable Supreme Court, the university itself was dissolved on 31/3/2014 without providing any opportunity under Section 48 of the CMJ Act 2009. The story of harassment of the family members of the chancellor, including humiliation of his wife and constant fear of injustice in the mind of his petitioner's son, the chancellor so and so, appeared before the investigator for more than 24 times, and on the rest he also remained in incarceration for more than 45 days. His wife was repeatedly called for interrogation to the police station on the pretext of investigation, made to sit for hours without following the direction as contained in the judgment passed in the DK Basu. Then, my lords, ultimately, they record the conduct of the judiciary also, and page 329. Bottom 7 line. When the entire state machinery, including the judiciary, was against the petitioner, as well as evident from the record and the conduct of authorities, hardly any person could hope to get fair treatment at the hands of the police during interrogation by the IO, except during reprieve like interim pre-arrest bail in the case in the so and so. Then I would not read. Now the conduct of investigating officer is mentioned at page 330, para 18.
But Mr. Singh,
Why I'm reading, I'll tell my lords why I'm reading.
observation you have to read in the context of.
I'll tell my the context. I'm telling my lord. Why?
339. What is
Yes.
the ultimate finding? The two persons were approached the court. They were protected by some directions.
I'm reading it for a particular reason, and the reason is
Those matters have been argued.
no. I'll tell my lords why. Because their whole game is that 83 crore, 83 crore. There was never 83 crore. And the investigating officer, we supplied all those documents showing that we have not done any hanky-panky. Those documents never became part of the charge sheet. And that is precisely why I filed criminal writ petition number 2 of 2021, asking the court to please allow me to produce them before making me allowed to argue on discharge. And that's precisely what was allowed. When the court saw all those documents, court says, all right, the horse Adalat Prasad's judgment, court says, since all these documents will exculpate you and there is no offense at all, you please go and get the documents from the court and file them yourself. Until that exercise is not completed, the trial is stayed. And this is that order. Kindly have I've given the copy to my learner friend, court master. Even though this copy was earlier also given.
This is the order.
And the investigating officer never cooperated. Rather, what happened when I went to the Malkhana, they removed all the documents from the Malkhana. And I have got photographs which we produced before the Honorable High Court, that they have now all the documents which were in my favor, they have put it to the weather under the rain. And now nothing can be utilized except the documents. And then we will ask the court, please allow us to restructure or reconstruct those documents. The court said, all right, whatever document is in your favor, you please produce it before the court. And that's precisely those 3,200 pages, which we produced before this honorable court also. They are all the attendance shot. They are all the attendance registers of the students who attended. They are all the attendance register of the hostels. They are all the 300 guides which I just read from this order. The guides which were appointed by us on their asking, Rather, it is not, we have just filled up those 300 guides. The investigating officer deliberately, in order to show that only 10 guides are there and so many 800 and odd PhD students are there, to show the disparity, failed to produce those documents in the challan or even mention them. That's why I produced all those documents by help of this order before this honorable court and before the trial court, and moved another application. Now, since the investigating officer has died few days back, we can't make some allegations against the investigating officer till a new investigation is appointed, and we be allowed again another chance to get the files which are in his custody in his office only, which were never given to us, even though they are part of the compilation of seizure, not made part of the challan and not found in the Malkhana. And what we found, so many documents which were not part of the seizure list, not part of the challan, but are there seized. Like this sale deed which we produced before this honorable court, original sale deed. This is neither challan, this is neither in the seizure list, but the original was with the investigating officer. When he was reprimanded in the court, he said, all right, he will give all the documents which are neither here nor there. I will give them the original. That's how the original came to be given. In the High Court, not in the trial court. Before I moved an application before Justice Dingo while the matter was pending here to give the document. We moved a special application, sought a emergent hearing, and in the emergent hearing, he was directed immediately to give the sale deed, because that is not forming part of the challan nor the seizure list. And how is it in your possession? That is the reason why I wanted to show only the observation, nothing else. That we have been hoodwinked. But I will show that the 15 crore also now. Kindly have the 15 crore money. The day when kindly note the day when they passed the provisional order. That was 4th or 5th of April 2017. Now kindly have a proceedings annexure 34 at page 587. The same, this is volume 3. This is that impugned order which was challenged in the Supreme Court, and Supreme Court by the order dated page 587, annexure 34. This is the same order from the Honorable the Chief Justice, 13/10/2015 order, where we were allowed to withdraw another 15 crore and 62 lakh. Earlier, there were two earlier orders. We were allowed to withdraw some 14 crore and odd amount. My lords may kindly note down, because their reason to believe does not express how many times we have withdrawn the money, and rather they say since we have failed to disclose it, that is hoodwinking the court. Rather, we disclosed about the PMLA proceedings also before the trial court. And since I'll explain that in a while. Kindly have now relevant page at 593. This order kindly mark the date 13/10/2015. In view of the aforesaid facts and circumstances, I am of the considered view that for enabling the applicant petitioner to meet the financial obligation of the CMJ University Foundation, the CMJ University, and also in respect of individual liability and that of family members, and to make CMJ University functional in terms of the judgment of the learned single judge passed in writ petition 177 of the present, an amount of rupees 15 crore 62 lakh 43,477.46 paisa out of the frozen amount of rupees 30 crore 42 lakh 87,000. So if the amount on 13/10/2015 was only 30 crore, they could not have seized by virtue of the two provisional attachment as figures, as per their figures, more than 27 crore. I'll explain. I'll come down to the tax also, the gross and the net incomes also. Kindly mark down the amount is 30 crore and 42 lakhs. We were allowed to withdraw now 15 crore and 62 lakhs out of this figure.
Yes.
But before that, the 30 crore, the trial court by the earlier order against which we had filed allowed us to withdraw 3 crores. When we laid a challenge that he has not allowed us in toto, he has only allowed in partial 3 crores. So 27 crore was the ultimate amount which was left at the time when the High Court also passed this judgment. Instead of 30 crore, it was only 27 crore. And out of 27 crore, 15.62 crore was allowed to be withdrawn in the year 2015, which went to the Supreme Court. In Supreme Court, we only said, all right, we will deposit the money, allow us to seek a defreezing again. So when the state went to the Supreme Court, the amount which was in the banks was only 12 crore and odd amount. 27 crore minus 52.62, 12 or all 13 crore and all. What figure they have mentioned now? Now they have applied their mind when they realize that 15 crore is gone, is never there to fill that lacuna. And that's why I will read. They never wanted to freeze another 15 crore. They wanted to fill up the earlier gap by virtue of which we had already withdrawn that 15 crore. So 15 crore was withdrawn in 2015 itself. When the matter goes back to the Supreme Court said, you please deposit back the entire 15 crore, make it 27 again, and file your application afresh. We filed.
When was the date of the Supreme Court order?
Supreme Court's order is 8/4/2016. That is at page 596. So nobody questioned, my lords may kindly note, nobody questioned the trial court partial allowing me to defreeze the amount. State never challenged it. 27 crore was our only amount. 15 crore was withdrawn. Now relevant is at page 597. Kindly see, it is my statement. Having regard to the statement of the learned counsel for the respondent, learned counsel for the petitioner states that the petitioner have no objection to the suggestion made by the respondent, except for the respondent first depositing any funds withdrawn from the frozen accounts consequent upon passing of the defreezing order dated 5/10/2015. This is the only operative portion. Court neither says which or where I have to deposit, how much I have withdrawn. Court simply says how much you have withdrawn, you go and deposit. On our asking, we only made a suggestion. You all right, we'll give it a quietus, we'll go back, do the entire exercise afresh. But the trial court order with regard to 3 crore was never set aside, was never challenged. So 27 minus 15.62 was 12 crore and odd amount, which they in the second provisional order says rightly reflected 13 crore and odd. All right.
How long will you take?
But only the factual, because my learner friend has created a dent which I had to only just this way. I had to just dispel those. I will, my learner friend may say so many things. Not that I wanted to run away and shrug off my shoulder, because everything has been done by virtue of the court orders. I will show the court orders because my learner friend does not know about the litigation there which we conducted. So I have never shied away from telling the truth in this honorable court. Even if he says we have pocketed the money, I will say how we have pocketed it in a defense. And rather what we are asking, my lords knows, we are not saying quash the entire order. We have given a personal undertaking, or rather a personal bond, as per the format itself, of 43 crore in toto. Apart from that, we have submitted 52 acres of land in a private sale. This is not a government land, because the other day my friend says the land is questionable. We have purchased it by way of private sale, affirmed. The government granted us the permission, and I'm a resident of Meghalaya. Not that my friend may say I'm a Bihari guy, but ultimately I can buy land, and because I got settled there in 1960s, I have got so many properties in Meghalaya. None of them have been taken away by the government, and rather compensation was paid. Very good. I'm so grateful.
But complete it soon.
I have come here to complete it today.
Not today.
In an hour, because I have to just show few.
Before lunch, you have to complete 1 more hour.
Very good. I'll be brief.
Because it's only a rejoinder. He had taken less time in his counter.
But he said more in his personal comments also because we never. But thereafter we deposited the money and the trial court defreeze the amount. This also happened prior to even the first provisional attachment order comes into force. Then, my lord, the state challenged that order of defreezing before the revisional court, that is sessions. In the sessions court, when the inquiry was conducted whether we had deposited the 15 crore or not, because that was the only ground taken by them, and the ED here that we have never deposited the money and how could the trial court defreeze the money? The trial court launched an investigation and directed the branch manager PNB Delhi to ratify whether the FDs which we had deposited with the trial court were genuine or not, and whether the amount stand deposited or not. The bank responded by a letter affirmed by the investigating officer later on that yes, the money was in fact deposited in the with the bank. Because, and second query was whether
But was the money lying in the bank?
no,
FDs.
not money, whether we have
FDs.
deposited, because we have to redeposit. What had happened was 15 crore 62 lakh, out of 15 crore and 62 lakh, 14 crore and 90 lakh was all in the shape of fixed deposit. Sorry, 15 crore and 30 lakh was in fact FDs only 11 lakh was cash, which was withdrawn by us. So the bank, the second query, which was sought by the bank.
What is the response, date of the response?
The report is, we have already given this. The order is 7/8.
No, the response by the bank.
The response by bank is 16th August 2018.
What does it say?
It says whether the CMJ University has made any deposits of rupees 15 crore 10 lakh as per certificate issued by your bank to the CMJ Foundation. If so, please furnish with account numbers, date of deposit and maturities, and also the amounts deposited and maturity value. Please also verify whether the amounts deposited are in the accounts as per honorable list of defreezed accounts, order dated 13/10/2015, and at page 113 also Supreme Court judgment order dated 8/4/2018. The above measurement please be sent on or before 5/9/2018. The bank responded by the bank responded by the letter dated 11/9/2018. There is this order I have also given to my learner friend. This is an order dated 24/10/2018, which records everything. It says
Order of the trial court.
order of the sessions court, the revisional court.
What is the date?
Date is 24/10/2018.
It records all this.
It records all this. IO is present in person and submitted that in view of the order dated 7/8/2018, he had written a letter to the PNB and on 19/9/2018, and he had received the reply from the Chief Manager, Punjab National Bank, New Delhi, whereby he had confirmed that the CMJ Foundation, customer number so and so, had made the deposits in the shape of FDRs for rupees 15 crore 10 lakh only, being maintained at their branch office, Greater Kailash. And he had also informed that they had already issued a letter of confirmation dated 11/9/2018, confirming the genuineness of the certificate. Further, it is also submitted that the bank had also submitted that majority and substantial of the amount mentioned in the list are fixed deposit. Hence, no bank would have allowed to reopen and reassign the same FD accounts once the customers had in cash realized the same, whether on maturity or not. He also submitted that he has also endorsed copy of the letter dated 19/9 and details of FDR deposit so and so. Further, the IO also submitted that at this juncture, he has no objection if the stay order is modified to the extent that the opposite party may be allowed to withdraw the amount deposited by them in the FDRs which they had deposited are as follows. Now, all those accounts are mentioned. How much is the FDRs? And further, the IO submit that the opposite party may also give an undertaking that in case the instant criminal petition is decided in favor of the petitioner, the opposite party shall deposit back all the amount withdrawn by them. Counsel for the opposite party agreed to the submission made by the IO, stated that he will give an undertaking as required by the IO and further submit that the respondent will withdraw only the amount deposited as mentioned by the IO in the FDR. In view of the submission made by the IO and also taking into consideration that the opposite party had also agreed with the submission made by the IO, the interim order dated 23/6/2017 is hereby modified to the extent that the opposite party shall withdraw the amount as mentioned above, which was deposited by them. And they are also given direction to give an undertaking that they will be bound by the final outcome result of the main criminal revision pending before this honorable court. Later, opposite party through she so-and-so had given his undertaking. We have given the undertaking for the entire 15 crore and 10 lakh before the honorable court that in case the revision is decided against me, I will redeposit the money. Then what happens? Criminal revision petition
Against the order of the session judge.
against the order of the CMJ is dismissed.
By the Meghalaya High Court.
By the session judge. After,
Or in the revision.
yes, the revision itself get dismissed. Because the contempt has been disposed of, we had deposited 60, instead of 52 crores, 52 lakhs, which were the shortfall, we deposited 80 lakhs also. So as of today, not that my learner friend, how say we have hoodwinked the court, everywhere we have given the undertaking also. Supposing tomorrow, the court comes to a different opinion altogether against me, I am bound by the undertakings given by me. I am a man of means also. Not that I am not a man of means. My learner friend may say so many things that I am a fly-by-night operator. I have been operating Shillong Engineering College, so many schools in Shillong. They are all run under me. And there is one fundamental flaw in this whole computation of income also. I have given, the disposal is also a few days back only, and on their asking that there is nothing left in the revision, kindly dismiss it. They got it dismissed. The investigating officer, the PP, this gets it dismissed. After the court hears that there is nothing left in the, because you made a false statement, like they made a false statement here, they made a false statement there, that we have not deposited the 15 crores altogether before the retaking up of the matter in view of the Supreme Court judgment. So in that view of the matter, the court says you have made a false statement. You rather misled this honorable court into granting the stay by making a submission which was recorded in the earlier 27/6/2017 that they have not deposited. Their first provisional order also says that we have not deposited the money. That is why we kept on saying that they have not applied their mind altogether. And this provisional attachment order, ECIR, which commenced in 2014, the money was all intact in 2014, entire 43 crore. They chose not to proceed against me for the last almost 3-4 years. When the last dates was there, because there is a period of limitation also, when the period was about to finish off, they issue me a first provisional attachment order without application of mine, that on that very day, the money of 15 crore, 10 lakh was already deposited. And that's why the Supreme Court ultimately says, you please go and deposit whatever is left out. And 52 lakhs. Supreme Court now, it is so very easy for my learner friend now to say, rather they can go and file a contempt also, because they are equally interested in this litigation. Let them go and file a contempt there if I have flouted any kind of order of the Supreme Court. Now this 15 crore, I have taken a loan and deposited it. And only after the court allows me to withdraw the money, I had withdrawn that 15 crore. That is never under the attachment order. They had attached what they did was, they attached the entire money what was pending in 2015. Not on the day when they had passed the attachment order. That should have been the exercise which they should have done under the Act also. Act doesn't.
The initial, then how was it attached without there being an attachment order?
The attachment, if the money is not even there, the money was never there. That's what I'm trying to explain from my perspective, that the money was only 12 crore and odd amount of 13 crore, what came to be attached. And this 15 crore, which they assumed that we will deposit it in the same accounts, which we could not. Because my lord knows, if the amount is all frozen, no entry inward and no entry outward unless until the court specifies. if the account stand defrozen in toto, I can't operate, I can't withdraw, I can't deposit out. Rather, my so much money got wasted because all the students who owed me or the people owed debt to me, they issued me checks for those accounts which are also before this in the seizure list. And that is why my grouse was that I lost some 2 crores and so much money, which we could not deposit because everything got seized, frozen altogether. That's why my whole humble request is that on the day when they passed the first provisional order, the money which was there, we have never touched it. That money stands as it is. We have only taken away what was allowed by the law. And the Supreme Court allowed it. And now the revision having been dismissed, nothing survives. And then there is one more fact I wanted to point out, that when we started this university,
One second,
in 2010,
just a minute.
Yeah.
Yes.
my income from my properties, all the properties put together, was around 7 crore in the year 2010.
Yes.
And that accumulates every year.
And this 7 crores has nothing to do, has
No,
got,
7 crore is the
has got nothing to do with your university earning. It is
no,
some other property.
that's the whole. What they did was, that's why I say this 83 crore, which they say was the total gross of the, not my income, but total gross of all the bank accounts in the last ledger, as if they, even if they have moved, they have taken away that entry also and the other entry, the double entries they have taken. In fact, there were 43 crores or odd amount, 45 crore at the best. But I already had an income of 7 crore in my accounts in the year 2010 when I started the
That
college.
is what we are trying to clarify. This 7 crores was from properties apart from the university, nothing to do with the
Yes.
earning of the university.
Yes, nothing. And then this income is kept on generating year after year.
Yes.
Which they have, it becomes a hodgepodge. Now 43 or 45 crore or 83 crore also includes this income. They have never been identified by the so-called reasoning of the ED or the investigating officer, that under what heading I have got the income. 9 crore income I get from the MOUs. 5 crore I again take a loan. The foundation, my lord may first understand I'll understand the concept. Foundation became the sponsor of this university. When the university started, it did not have that 2 crore also corpus to have an endowment fund. The foundation took a loan of 5 crore, put that money into the university, create and gave a 2 crore of endowment fund, which came to be objected by the higher education department. They said the endowment fund has to be given by the university itself. That is what they are now hampering upon, that we withdrew that money. We never withdrew. We just then took the money back, the FDRs, reconverted them into cash and gave the money back to the university, and university created an endowment fund which is also lying in a seizure. And that's what I can get a report from the trial court, that endowment fund is also lying seized with this very income. And the UGC has not taken any action.
Statement was made that the endowment fund was created only for the.
That's what I'll re-explain it. Endowment fund, which was created for a day, was given by a CMJ Foundation and not by the university. So they asked me, since you have given it, you please take it back and redeposit it under the name of CMJ University. And we did that. That endowment fund is still there. And that's a precise reason.
Yes.
He say he cannot comment. If he says
UGC report. I will just explain.
what I have come.
Give me that compilation.
Closed on so and so.
Now my friend is coming up with this plea.
I'll just show. Just that it will be. I have got the document. The documents. I am not going to take it out of my pocket. I have already filed it with the UGC report submitted by me. with all the inspection. No, the earlier one. It's 2019. They are at page, all these are at page.
Just a minute.
They are in this compilation which I filed, my lord, the volume 7, the very
Page.
big compilation. They start from 3011 of this compilation, 7 volumes we have filed. And we had given it to the UGC into year 2012. And this also was not challaned or made part by the investigating officer because it also includes a list of those 300 guides under contract with us, intentionally not given by the investigating officer. Otherwise, there was no case at all against me. This was given in the year 2012. The UGC also recorded the report submitted.
Give the page number again, 3011.
3011. If from 3011 to 3032 are all my lord 10 lakh, 15 lakh, and in penultimate 1 crore, 14 lakh, 70,000 and odd, totaling 2 crore.
7 volume.
Yes. There are multiple FDs. And we again resubmitted them, this particular data, to the UGC under section 2F inspection. This is all a record, my lord. I would not dwell because I have got something else to tell you. 3011, 7 volume, volume 7. This is part of my report. It starts from volume 6. These are the 2 reports filed by us. It's a very lengthy document rather. Start from 2626. This is after every 3 years we have to submit a report to the UGC. So this is part of it. And along with this report, I have also given to the UGC my lease deeds in Laitumkra,
The 3011 is you
the
cannot
FD.
read, not legible.
I can, it starts then, my lords, may kindly have 3016. And 3011 is the (3032) is the report also. And the 3034 is the next report for the year 2019. The first report is of 2012, duly submitted, verified by the governor, but ignored, not made part of the challan. It also includes the list of 300 people, which I had also supplied in this very voluminous document. Those 300 people came to us as guides. And they were all PhD degrees. They are all professors or D.
You said they were on contractual basis.
They were on contractual. Earlier, the UGC minimum requirement rule was that each guide can take up 8 students as per the rule. But I had 300. So I had 300 guides, more than 300 guides, and 10 supervisors, which they are only accounting for. But D holds that. Now kindly, I will come down to their Allahabad judgment. Now Allahabad judgment, my lord knows the last paragraph, which says in case something comes up, it can be revived. The revival happens this year. The court master. A copy to my learner friend. This order is few days back, 16th March 2023. The first my lords may kindly have para 2. This is BTC training course 2012. Again under the period of shadow, 2010 to 2013. So the period is 2012. Now kindly come to next page, my lord. The earlier, whatever my learner friend has read, is all considered, or rather brought to the fore.
Page?
My second page. I'm so sorry, my lord. It's
Paragraph?
back to back.
Paragraph?
Para 4 only, but it starts from the top only. Whereby the training of the petitioner has been discontinued as per the judgment of this honorable court dated 19/11/2013, passed in writ A 36180 of 2013, Satesh Kumar and others versus State of UP. This is annexure 15 of my learner
Yes,
friend at page
yes.
1052. I hope.
Yes, we know.
Or I would not, because this is the same very judgment, which follows that the degree obtained from CMJ University Meghalaya from academic year 9 to 13 are invalid. The said letter of the principal died, Manipuri, has been appended at page number so and so of the writ petition. Subsequently, the petitioners challenged the order dated so and so passed by the principal Manipuri by way of writ appeal 3775 of 2014, which was dismissed YD judgment dated annexure 16 in his compilation, that the justice, as he now is the Chief Justice of India, passed and while he was holding a division bench, dismissed the revision and granted the same liberty in case something comes up, you come back. And that's why all these people have come back. And kindly have the last para now. Para 12. I may not bother my lords to everything is recorded here. In view of the aforesaid, the BA degrees obtained by the petitioners from the CMJ University Meghalaya are valid in the view of judgment so and so and amendment in section 48 YD amendment dated in the facts and circumstances. Degrees obtained by the petitioner from the CMJ University Meghalaya in the year are treated to be valid one. Because new law comes in, they can take the benefit because I am under the criminal law. I can't take the advantage of that law. But needless, if my learner friend will the ED can advise the state government of UP to take up that litigation. Yes. Now, as I was saying that my university is still running and functional, the EC decision 25th and 26th June 2022 approved and ratified by 116 Committee of Council has ratified my degrees. There is, I think, some pagination problem is there, man. Yes, kindly have this. Good master. Yeah, there was this inspection also. We are awaiting the decision of the video inspection order conducted by
Rehabilitation Council of India, statutory body of ministries, social justice and empowerment, development, and persons with disabilities, Divigyan. But here, kindly have the bottom 3 atom. My university is mentioned. Faculty of Pharma, CMJ University, Sub District Uming, District Rebo, Meghalaya, PCI D Pharma and B Pharma. Second column, D Pharma and B are the controller of examinations, CMJ University, Jorabat, Meghalaya, D Pharma. Grant approval for 2022-2023 academic session for the conduct of second year for 60 admissions for D Pharma, 60 students for first session, and B Pharma grant approval for 100 admissions for year 2022-23. Supreme Court order is prior to. Supreme Court order is 2021. And if any court commissioner can be appointed to, I can only say we are running and functional. And then
This is a part of what?
it is a part, kindly have the top. I can bring the entire
No, no, doesn't refer.
on the mobile. I could not.
No, no, it's not record.
Not on
273 is the
It
part
is
of
a
which.
part of the. No, it is a part of a decision of 366 EC of the main body, because I am a university myself. I am only seek a recognition or
Decision
or
of the
approvals.
decision of the executive committee.
yes, MCI, because all the courses under D Pharma and B Pharma would fall under the MCI only. But if my lords may give me time, I will submit the first copy also. And then my learner friend's argument was we are operating from one room as per the report of the expert committee. First, the expert committee went on a day. I will show that date also. Now that date is very apparent, because in the website also they mention the date as first. I've got the UGC record also. I'll just show only briefly. This is the latest list. UGC approved university list of 2023 in India, state-wise list. I am at rank number 1. Total universities 10, private university 9, central university 1. I am CMJ University 1. Kindly turn over to the page 2, my lord. This is the UGC's own website showing the status for the year 2023. Now, kindly have, I am at serial number 83, private at the top only, CMJ University, so and so Meghalaya. View website, rather if you click on this view website, it goes to my website. Then kindly turn over to the next page. Again, UGC, CMJ University status of inspection by UGC expert committee. My lords have it. This would be the, actually, since it's a back-to-back, 1, 2, 3, 4, 5th page, since it's a back-to-back. It's this page, my lord, with a single entry.
CMJ,
Eh?
CMJ.
Yeah, CMJ. CMJ date of establishment, date of gazette notification. Now kindly see that as per the UGC, my date of notification, gazette notification is 22/7/2009. Whatever they are reading, but as per the UGC, we commenced in 2009 only. Date of information submitted by the university, kindly see this is that information for the 2012 which I just showed with the endowment fund, 22nd March 2013, just prior to the registration of my FIR. 26th March is the FIR. I had just given all the information to the UGC. Why wouldn't I give it to the governor also? Then expert committee constituted, yes. Date of visit. Now kindly see this date is important. 1st August 2013. In the same 5th column. Date of visit.
Yes.
Is 1st of August 2013. I was sealed from 27th April to the order passed by the trial court for at least allowing de-sealing of my university. And that happened in 2015. So for this year, the expert committee could not have visited without the permission of the court, and there is no mention about it. But I will leave that apart. Kindly have the status of university.
These prints are from the UGC website.
Yes, my lord. My friend can also check. I have personally taken it. So there can't be any hanky-wanky about it. If my learner friend will also go and visit, I can show it from my mobile also right now. This would be the same website which will open. My friend may visit, but my friend is visiting about the website. Like we were asked, have you visited the murder site? I was asked. So
He had gone to the site physically and has visited the website.
Yes, very well. Now the status of university. This is also both ways, my lord. Status of CMJ University.
Yes.
I would not read the first portion. My lords may come to the second page of this report and the fourth para.
The director,
This is that, my lord, para which would
director,
yes, principal secretary, government of Meghalaya, fourth para. On the second page of this status of CMJ University. It will be back, my lord.
Yes, 5/6/2014.
Yes. YD letter dated 5/6/2020 informed the UGC that the CMJ University has been dissolved by the government of Meghalaya under section 48(2) of the CMJ University regarding validity of the decree. Has been informed that hearing on the representative of the students have been completed, keeping in view various parameters, including those indicated by the UGC. A total of 1643 students attended hearing and 4803 were absent. A total of 1479 cases, the degrees are found to be invalid. Out of 6,700, 146 are invalid, not illegal. For whatever reason, I am only hampering on only one aspect. ED comes into play, or the criminal jurisprudence will come on only into play if all were proceeds of crime. If everything under the sun has been a proceed of crime. Now, how many students are there? 1479. And those are held to be invalid. My lord knows, in my school, in case you are less than 70%, or rather less than 75%, and the university supposedly gives me a year ahead, they will later on send me back or ask me to re-attend the classes and make it invalid. That's invalid. Rest of the degrees, they total come to 6,700 and odd degrees, or students, not degrees, the students, and 1479 are the only degrees which are found to be invalid. Now, where is the application of mind, my lords? I ask myself, in case the ED was so prompt, so impromptu in figuring out 15 crore has not been deposited, have they applied their even mind also as to what is the UGC report? Even today, and this has been there from 2017 onwards. Why I wanted to show now is, otherwise, for every year I have got a report. Every year the same number of students. And those 1479 students are now petitioners in another litigation which pending awaiting the outcome of the main SL. So if somehow or the other it is held that the entire expert committee's report was bad or malicious, or on a day when the university was shut down, I can only foresee the impact of it, that the UGC also and the state government had to recognize or rehear the entire matter afresh. That is the purport of under 48 also. 48, I will reread it again. 48 says all the malpractices or everything has to be considered by the government independently, deholds the opinion of the visitor. State government filed a clarification before the Honorable Supreme Court, and this is the order passed. And Justice Singhvi sorry, it came before another bench. The court clarified that it has to be in accordance with law. This is the order dated 2nd of January 2014. This is an application is filed on behalf of the state of Meghalaya for extension of time granted by the order dated 13th September 2013. My friend was so held reliant upon that judgment for taking decision in accordance with law and order passed by this court. The main order said you give them a show cause notice, and that's what the whole litigation is all about. That we said 48 envisage a different rule as to how the government should come into or take decision, not on the strength of the letters of the visitor. These are all other orders passed by the various students, giving them personal, and that is why I say those writ petitions are pending. I am one of the respondents there, but and I have also filed a writ petition against the UGC because I was not made part or allowed to give any kind of documents to the UGC to supplement that the students had in fact studied and they had their coastal.
You want to say that the validity of security issue is presently sub judice?
Yes, the
That-
entire issue is sub judice.
There is no conclusion.
There is no confusion with regard to that.
There is no conclusion. No
There is no
determination.
conclusion, but there is no confusion as to with regard also that it has not been culminated. There has been total non-application of mind by the CID officer and by the ED in coming to a conclusion that all under the sun is proceeds of crime, because if the double entries are there, then the entire gamut of the decision-making process gets hit. And then I rely upon one judgment which was earlier also read, and since my lords were of the view that we are only seeking to stay this whole process, and that finds support from the judgment of the judgment in the P. Umar Reddy case of Karnataka High Court. But I have also given a copy earlier. In my case, trial is stayed, that predicate offense is stayed as of today. I have got an order also from the trial court.
What is the citation here?
The site is, it's a writ petition 19337 of 2022 GM-RES dated 14th of December 2022 between Miss P. Umar Reddy and others. These are all the ministers over there, and versus Directorate of Enforcement.
Yes.
Now, what I will read is,
Do you have a copy?
I had also given a earlier a copy. I'll keep my paper. My lord's views are fortified from this judgment also, wherein it is kindly have the internal page 24. Or the entire judgment was actually dealt with Madan Lal. Madan Lal is a fundamental law. We don't have any qualm with that. And but I, with foremost respect, I say that that does not have any kind of inclination to our matter or eclipsing. But I am praying.
Paragraph?
This is para 14 only, but at internal page 24. It reads the judgment of the Supreme Court. It also is on the aspect of the reasons to believe. In clause D of the aforesaid conclusion, the apex court considers section 3 of the act and later upholds the constitutional validity of section 5 of the act in terms of clause 6 supra. Section 5 of the act is what deals with the attachment of the property. Clause 5D of paragraph 457 supra establishes the link between the two. Apex code holds that in the event the accused in the PMLA or whose allegations are linked to any person in the predicate offense, such accused in the predicate offense gets a clean sheet on 3 circumstances: one by one by acquittal after a full-blown trial, 2 on discharge by the competent court, and 3 on the proceedings being quashed by the High Court in exercise of its jurisdiction under section 482 of the CRPC. In these circumstances, the impugned action under the provision of PMLA cannot be permitted to be continued. Therefore, if the allegation and the predicate offense are considered to be the flesh, the offences under the PMLA is the blood. They are impregnable. Therefore, if the predicate offences are permitted to move forward, the impugned proceedings cannot. It would have been altogether different circumstances. The petitioners were all acquitted by the offences under IPC or any other predicate offence to which the offences under PMLA is linked. The situation in the case at hand is not with regard to acquittal, but the stay of the proceedings. Therefore, they are eclipsed and not extinguished. The apex code does not deal with the circumstances as to what should happen in a case where it is eclipsed. The apex code only dealt with the situation where there is extinguishment of predicate offence. Therefore, it is necessary to consider taking cue from the findings of the apex code as to whether attachment orders should be permitted to be confirmed or otherwise. It cannot be disputed that at a later point of time, if the petitions are acquitted, no proceeding of the ECIR can continue in the event they are convicted. It is always open to the enforcement act to pass any order or attachment or conviction as the case would be, if that be the right of the enforcement act, since there is no determination in CC in the light of the interim order being granted by this court. So long as the interim order is in operation, the impugned proceeding in the considered view of this court cannot be permitted to continue. Failing, it would run completely counter to law as enunciated by the apex code. Then it relies to one judgment of the division bench in V. Shanmugas. It's in the Chennai High Court. And then at para 33, it stays the entire proceeding. Para 19 at page 33. Insofar as the judgment relied upon by the learned counsel appearing for particularly with reference to and so rendered by the High Court, that original proceeding under PMLA and so and so predicate offence are completely different. They can go hand in hand in concern. There can be no qualm about the principles so laid down at the relevant point in time. With the judgment of the apex court in case of Vijay Mandal, the judgment in J. Sekhar would not become applicable to the facts of the case. The order judgment relied upon would also follow suit in the light of the judgment of the, and it is state till disposal of writ petition and criminal petition of purpose, and they are state. This has not been challenged by the enforcement directorate as of even today. So this was passed in December, and that can be also assumed that the government came in. So my argument is, or my appeal to my lords is only this much, that we have already given an undertaking for entire amount of 43 crore, de-horse whether it is a procedure of crime or not. I have also given the original land title also to this honorable court, totaling 52 acres. And even assuming the worst sales scenario also, even assuming it is 1 crore because it is on the highway, abutting the highway at Jorabad, the value can't be less than 1 crore. And 52 acres coupled with my bond would take it totally in the entirety, the 83 crores also, in case they ever realize that they have bungled up and the entire money is 83 crores. Assuming for the sake of argument also against myself, that they are all secured. And as regards that there is no law under the swapping of the property is always considered. Here we are talking only about the some money is left in the I am still a running concern. It can't be unless until their case was that entire thing was stayed. Otherwise, why would the government file an SLP? I asked this question. Why would the state file an SLP challenging the same very order which granted them the right to dissolve me because I had not challenged the or that impugned order within time or secured the or got the stay order after 10 days? Beyond 10 days of, because it should have been 10 days, there is a difference. State would not have filed their own SLP. And why take a stay against themselves? I posed my question because the reason was there was no stay as such. There can't be a stay Because when the Supreme Court grants stay, my lords, whatever is in the domain when we filed, because the SLP was filed on 17th of May. It got listed on 1st of June. Because there, my lords knows there is a vacation period. Now also there is a vacation. It takes time. It is not a demolition case where something was to happen. And they had not passed a fresh order of dissolution. The only thing that the High Court did was remand the matter back to be decided on merit. And state having filed the SLP, it has to be assumed that the dissolution was not there at all. Both are unhappy with the order of Justice More in the division bench. And that being the condition, my lord, we are operational and we need money to run the institution. This is not my personal account. I can give another undertaking to this honorable court that nothing would be spent on myself. I am expending by the day. Convocation was held in 2018. The governor attended it. And from 2018, we are in 2023. And we are talking about a dissolution which was passed in 2013 or 14, sorry. And even assuming the court says dissolve the new act does not give the power to the government now, my lord. The amendment has taken away the powers of the government to dissolve me now. It again rests with the governor as per the 2019 amendment. That is why this judgment also records the Allahabad High Court. This is from the Allahabad High Court only. This has also not been appealed by the state. And as regards, he says only one, as regards, he says it's an operation from one room. Kindly have his own one document, which he says is a Google map, even though this is not part of the challan or anything. The 2010 Google report shows that there is there are structures at page an extra 25. I don't know what was the designation has changed. 1201. Sorry. Google. 1126. 1196. Sorry. 1196. An extra 25. If Google map is seen, the entire structures are all built. And as regards the lease deed, around 35,000 square foot was under lease. I have given in my volume 7. And that was 33-year lease taken in the year 2009. So 33 years lease would have outlasted anything. It's in perpetuity basically. So not that I was operating from one room, and VC appointment, my lord, I was only to seek the approval, not prior approval, the approval, which the 177 judgment said that there is a deemed approval. And that's, as we speak today, stands as it is. There is no change. Chancellor is validly appointed till the time 177 writ petition is not set aside. And then there is my friend said that we could not have taken the Shillong Engineering College.
Approval was from the visitor.
What?
Approval was from the visitor, necessary was from the visitor.
Yes.
You say there is no requirement of prior approval.
Yes.
It was a case of deemed approval.
That's what the single judge held. And that is still standing as we speak today. And there is one more thing, that the affiliation and the de-affiliation, I have got a power because I'm a university now. I can affiliate any college under myself as per section 7B and 8G of the CMJ Act.
So that's
Because my learner friend said, I'll tell my lords, because they said we started functioning with the students who were already in second year.
that you have explained. You have taken over the
We had
Shillong
two
College of
more
Engineering.
we had two more colleges. One was Shillong Engineering College. One was a medical college. We had all affiliated to ourselves.
Which medical college?
There was a medical college also.
Name?
I will just take the name. It's all mentioned in the UGC report also. And now also we are running one medical college in Gurgaon, one very big institute, in collaboration.
You mean CMG is done?
CMG. Well, we have been in education business right from 1970. Earlier we were operating schools, which we ultimately sold to become larger. We became Shillong Engineering College thereafter. So not that I'm a fly-by-night operator. I am so grateful.
I can I what's the time that I think of the- of the- so what the- what the- what- 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 what-
The Allahabad which I just handed over, that pertains to 2012. Whether I, so I'm restricting my claim only with regard to defreeze. My we had separate application also. We can keep this writ petition alive or as well. And my application for defreezing the accounts is there. To swap it along with the securities we have just given along with the
The architect. You appear as what? Okay, okay. Okay. Who has not looked at the architecture and DHA continued this argument and has the Manpreet Singh current form is also heard. Who has also submitted his rejoinder. The hearing is complete. Complete. Judgment.
the interim to continue. Because there is an interim granted because otherwise they will pass some kind of order.
They were not passing any orders.
But they have already passed an order, they are just not pronouncing it. Without hearing me, they have already,
They're not, they cannot do anything. How can we say that?
but I was there on the, in
Now,
the
how can we
court.
say today the interim is extended? We have reserved for the judgment.
Well, I'm saying till the time it is not
It is there.
very well.
Don't do anything.
Grateful.
Three and what are three and who is for the other side?
Yeah, Malab, they will come in the second of Malab.
And the other one, four.
I look for
Okay. Okay.
Start Malab.
What is the matter?
Malab, regarding Malab provincial election, Malab, Malab, I
Is
was
it a long matter?
Malab.
Is it a long matter?
No, Malab, I'll take 10 minutes.
I don't think it's a long matter. Short matter.
Yes,
We'll take a chance, but otherwise, if we have time, we have to write some judgment. If it doesn't come, we'll have it some other day. Let us call the other matter, there is another matter. So 15 matter, if he comes, we'll take it up. Item 4. What is this?
Well, this is relating to the pay scale of the seniority system of newly provincial and college employees. And what happened was here. They are
The last you are there for the department. Finance who is there? Names shown, or names has been shown.
Yes.
Can you call Mr. Gogoi or Mr. Chalia, anybody? What is the case? Just in a nutshell, without opening the brief, what is it?
The purpose of the employee lordship, the provision is under the Act of 2011.
You are an association.
My lord, that is it.
What is your,
A
what
grievance
is your
is
grievance?
there,
Hmm.
lordship. Prior to lordship ROP 2010, the basic pay of senior assistant was 3850. After ROP lordship, the scale of pay to the senior assistant has been enhanced to 7170. That has not been provided to the senior assistant. That is the grievance,
That is the only grievance.
my lord,
The benefits of the revision of pay has not been given to
has
you.
not been given to the
But ROP is, when was the ROP of? 2000 and
2010.
till now it's not been given.
my
Are
lord.
they raising any issue regarding your entitlement for such ROP? Have they raised any issue questioning your entitlement towards such benefit?
Earlier lordship, we filed a repeat issue.
That's not the question. Earlier,
The plea waiver appears, my lords. He's in court one, my lord. Much lordship, if a short accommodation can be given, my lord.
see, his grievance is that ROP 2010 benefits have not been given to
Yes, sir.
the members of the association. Is it your case that they are not entitled to such benefit?
Lordship,
Or is it your case that due to some procedural dilly-dallying, the matter has not been done?
lordship, in the affidavit, we have stated that he has been provincialized in 2011. That is why he's not been given the prior benefit.
Oh, he is seeking a retrospective
Yes,
benefit
my
of
lord.
it.
So, lordship, here, I apologize, my lord, because I'm not well versed with the matter of the plea waiver. He's in court one, my lord. If the matter can be taken up day after tomorrow, my lord.
Day after tomorrow, we'll complete.
Short accommodation.
You want to, your contention basically is that to get the benefit of ROP, he has to be a regular employee prior to,
Yes, my lord. That is why. those
at least at the time when the ROP was brought into force. His service got provincialized after the date.
Yes, ma'am. So that is why the benefits are.
You come prepared on that
My
aspect.
lord. But some employees have already been prepared. So may I feel of it, this matter may come in the top of the hearing. lordship.
So we'll have it day after tomorrow.
There-
Uh, a prayer for accommodation has been made on behalf of the B. Gogoi, Clarence, Standing Council, Finance Department, Para. Three, M. Khan Learned Council for a petitioner, however, submit that the matter is pending since the year 2017. And some of the members of the association, intervened have retired from service. And therefore there is some urgency for Sapara. Considering the above, list for hearing. On Islam. I'm Islam.
One of the respondents is here.
Gogoi is for one of the respondents. Beneficiary.
Another is for the principal, my lord, headmaster.
What is your stand towards him or towards your other side, respondent?
Well, my lord, what happened, my lord, the headmaster, present headmaster, my lord, when my lord, the provincialization took place, it was a ME school, my lord. Later on, my lord, after it was provincialized in 2013, and then my lord, in 2017, it was amalgamated with a high school, my lord. So my lord, he is the headmaster of the high school, so my lord, he was not acquainted with the
What
facts.
is your grievance?
My lord, I was the, my lord, founder teacher of the
ME school.
ME school, my lord. I was appointed in 1986, my lord, and he was in 90, my lord. But my lord, my lord, he has been doing the benefit, my lord, and I am so, not only that, my lord, I am shown as junior to him, and that about my lord, it was shown, my lord, that I was dismissed for service.
What do you teach?
My lord, language teacher, my lord, both are language teacher.
But you have been shown to be dismissed from
My lord,
service.
in 2007, my lord, when my lord, all this are going on, my lord, I was running from clear to post, and my lord, it was admitted by them that no notice was given to me.
But the dismissal order has been interfered by this court.
My lord, that was under challenge, my lord, as well as his.
What happened? Here,
Here.
your dismissal also.
My lord. In 2014, my lord, 14, my lord, they have given me that, my lord, that I was dismissed, my lord. Whereas, my lord, 13, it was provincialized, and I was, my lord, I was fighting for my case, my lord, since 2010, 11, my lord. I was never informed, my lord, and they have admitted that fact, my lord, that I was never given a chance. My lord, no notice was served to me, my lord.
Day after tomorrow. Okay. 2-3G Kusam Learning Council for the petitioner. No. Heart 3G Kusam Learning Council for the petitioner. The department is represented by Sri Ms. Sharma, by Sri P. Sharma, P.N. Sharma, Standing Council, whereas the response number 9 is represented by Sri A. Gogoi. However, the Learned Council, however, 3M is Learned Council for the response by 11. However, some accommodation is sought for 3M is Learned Council for the response by 11. Considering that this matter is pending since the year 2015, please for action hearing carefully. This matter we could have easily disposed of. What is your sense?
Guys, under 2011 Act. So the 2011 Act no longer in force. Now,
17 Act.